Hello, good afternoon, everyone. Today we're going to talk about family based immigration. What is family based immigration? We're going to go over everything step by step so we could understand. So, this is not a legal advice, so this is going to be a video only for educational purposes. So, let's get into it. Family based migration is the easiest way people get their green card in the US. They do call them the low hanging fruits. And because of that, there is a lot of mistakes in this application because most people do them by themselves. So today we're going to go over the roadmap of family-based immigration. So first we have the foundation, which is the I-130 petition. This is where basically the family prove that they are the family proved to USCIS that the relationship is real, because there is some people that trying to do fraudulent thing. And the I-130, this is the base, this is where you establish the relationship. We're going to go over immediate relative and family preference. We're going to go over the waiting list, who have to wait, who doesn't have to. And we're going to have the protection, which is CSPA waiver and the final steps. So let's get into it. So let's talk about first the form. This is the which is the I-130. This is where establishment this is where they establish the legal relationship between the petitioner, the US citizen, or the LPR, and the beneficiary. So you need to prove identity for both parties. You need to confirm qualifying status, and for for some, you will know your place in line. So we're gonna get over that in a few. Okay, so let's talk about the green card reality. The I-130 is just the first step. It does not automatically grant you a green card. After approval, you'll be able to do adjustment of status or consular processing. Today, we're only going to talk about adjustment of status. We're going to leave consular processing for another video. So the fast track of immediate relative. So for USCIS, close family of US. This is for close family of US citizen only. Those categories are high priority. Those they are VIP. So they could send their I-130 and immediately they will be able to send their green card. They don't need to wait in line because they are close family of US citizen. So who are those people? We are talking about spouse, legal husband or wife, or U.S. citizen. So it doesn't matter if a same-sex marriage, as long as the marriage is legal. So you are considered as immediate relative, and then you can send your green card with the I-130. You don't need to wait in line. We have unmarried children of U.S. citizen. Unmarried children of U.S. citizen, if you are a US citizen and your child is under 21, you also can you don't have to wait in line, your priority. And we are talking about parent of US citizen. The children of course need to be 21 years or plus. So USCIS only consider children that is over 21 years old to can fill for their parents. So the advantage to be part of the immediate relative, you don't have to wait in line, you don't have to wait years and years before you send your application. So your priority. So this is the difference between immediate relative and not family preference. Now let's go over family preference. Family preference is subdivided in multiple categories. So we have F1, F2A, F2B, F3, and F4. F1, the people that are under this category, they are like unmarried son and daughter of US citizens. So if you are under 21, you can go if you are unmarried son of daughter of US citizens, you are over 21, you are part of the first category, which is F1. You will need to wait in line. If you are the category which is the F2A category, it's spouse and unmarried children under 21. F2B, it's unmarried son and daughter over 21. We have F3 category if you're son or daughter of a US citizen and you are married. And you have F4, which is brother and sister of uh, brother and sister of US citizen. For US citizen, only US citizen can petition for their daughter, for their brother and sisters. Okay, so these are the category that will have to wait. Those category will, when they send the I-130, they will receive their priority date. This mean the priority date, it mean basically they'll a number on the waiting list. Okay, so we spoke over we make the difference between immediate relative and family preference, and we did go over all the category on the visa bulletin. So basically, priority date in visa bulletin, what is it? It's basically the date USCIS officially receive your I-130, and it is your unique place in line. The visa bulletin is published every month by the Department of State. It reveals it reveals when your line is moving based on your category and country of chargeability. So every month, if you go to the Department of State (NBC), you will see the current charts. So on the chart, you will see which date they are serving right now and which country also they are serving right now. Where do you get your priority date? If you ask, it's when you send your I-130 out, the date that you receive, you send it out, and then it's on your paper. This is your unique place in line. This is your priority date. Okay. So So how can you prove a relationship it's a relationship? Let's say if you're married, what does the USCIS need to see so they could say, okay, or marriage certificate is not enough, but you also need a few other documents. Like you need to have a few pictures of social media. You will have to have a joint bank account together. You will need to have lists that you guys are living together. You will need to have affidavit of friend and family. You will need to file taxes together. You will as music teachers, when after you send out your application, you need to have a shoebox, and in that shoebox you start collecting document, everything. If you go out have dinner, you go to a funeral, you put in that shoebox. This is where you will prove us. This is where you're going to start building and start proving, where you're going to prove to USCIS that you guys are on a real marriage. So let's go over uh qualifying relationship, proving qualifying relationship to parents and children and siblings. So those you only need birth certificate. Sometimes they do request for DNA tests. For stepchildren, the marriage need to be occur before you turn 18 years old. Okay. Immigration scrutinize fake marriage and fake document existently. So they will double check. It's not like, okay, some people they live together on an apartment list. They don't put the other person is not on the list. They just uh, Adobe screenshot, Photoshop it, and they add the list. They will scrutinize. So you guys need to make sure everything you need to send to your ICS it's real. So start, if you're married to somebody, start building those proof so you could set out. So we're going to talk about exception. You guys already know every rules have their own exception, and CSPA is one of those. The CSPA is the age freezing protection. What is it? It's under under the Child Status Protection Act. The government may freeze a child age for immigration purposes. Without CSPA, a child hanging out will shift from a fast category immediate relative to a slow category or lose eligibility. So how does what is that? How do we calculate that? So let's say uh you are a son, you are a child of a US citizen, and your document process started before you turn 21. Let's say you were 19 years old. So the USCIS will, and then by the time they approve your I-130, you're already 21, you're already 21 or 22. So the USCIS, they freeze your age, and they will consider only the date you receive your priority date, which is 19 years old. So this is a good thing. So a lot of kids, when if they saw their document so they don't lose their status, this is a very good tool. So this is a very good act. So we're going to talk about admitted or parole. So we cannot talk about family-based immigration without talking about the qualification. Let's say you do file I-130, you are in the United States, and then your application is approved. Being admitted legally or being paroled, it's one of the best things that could happen to you. So when you are submitting your adjustment of status, you need to be admitted. You need to have I-94. You need to be inspected at the border. Okay, so to adjust your status, to set out your I-94 inside the United States, you typically need to show a lawful entry through inspection. Okay, or you could have been paroled, but you need to be legally authorized to be in the United States. So let's say you did come illegally, you did not get admitted or parole, or can you overcome inadmissibility? The only way you could overcome that is through a waiver. So there is different type of waiver. We have the waiver I-601 and we have the I-601A. Okay, so those they do forgive unlawful presence, forgiving 3 to 10 years bar after staying for long, misrepresentation, lying to a U.S. officer or fake document. Those people that get into the United States, they were married and then they were not married, and then they did say they did lie to the U.S. consulate and say that they were married. So those people, we call that misrepresentation. If you have a criminal history or if you have extreme hardship. So for those, you do need a lawyer to help you with that. So if you are being committed of a crime, if you committed a crime, you have lied to the U.S. The consulate, or you have been here illegally, so you need to talk to the lawyer so you could overcome those inadmissibility through a waiver. We do have a few special provision, which is the Cuban Adjustment Act. The Cuban Adjustment Act is a different law for the Cuban. That means if they've been in the United States over 1 year, they can do the adjustment of status, and also for the Liberians. So those are the exceptions. So if those people come to this country, they do not have to go through what everybody's going through. After 1 year of the United States, they have specific rules or laws that protect them, that could take them to special route to get the green card and later citizenship. Every case require, of course, every case is require analysis and regulations. So those we're going to talk over. We're going to talk about the special form that you need to send out your adjustment of status, which is the I-130, and it is, you guys are married. This is for marriage. Is I-130A, the I-485 itself, I-64, which is the affidavit of support, where that person certified they will provide support for you after 10 years or when you become a U.S. citizen. And we have the travel authorization and work permit. So while your status is pending, you can have your work permit set out. Or if you do it through consular processing, you're gonna have to file the form DX-260. If you guys have any question, you guys could contact me. I'll be happy to help you with your questions. Thank you guys, and I'll be sending another video talking about consular processing.